Hi, I'm Steve Carlson, a candidate for president in 2016 from Independence 2016, an offshoot of the Minnesota Independence Party, which was destroyed by a conspiracy by the Republicans and Democrats in the 2014 elections, which I have contested all the way to the Supreme Court. And here I'm contesting it to the U.S. Senate, who have a duty to protect the vote and to protect the rights of third parties in federal elections, which this is about. And I'm just finishing up in this fourth video the argument which draws on the Supreme Court's decisions on what it means to have a free and fair elections. We'll start with in Ex parte Yarborough, and I'm going to offer a few excerpts from some of these cases, looking at an 1884 case, Ex parte Yarborough, 1941 case called U.S. versus Classic, and some other cases. Now, in both of these cases, the Supreme Court clearly determined that the right to vote in elections for Congress is derived directly in the Constitution, Article 1, Section 4. It doesn't come from nice people around Minnesota. It is yours because you're an American citizen. This violates the 14th Amendment for anybody to take it away, even if the DNC, like Debbie Wasserman Schultz and Hillary Clinton and Bill Clinton, want to take the vote away from you. It's in the Constitution, and somebody has to stand up and fight for it. Now, in the Ex parte Yarborough, votes were taken away from a black man, I believe by threatening him and brutalizing him on the way to vote, if I recall. And there was a law set by Congress which says you can't do this. And the state comes back and says, no, we can do this because this brutalizing and assault are state laws and they're not federal laws, so we can do this. So that's what Ex parte Yarborough was about. And the 15th Amendment was this going to be able to protect the black man from voting or from being beaten up by people because he was going to vote. So in Ex parte Yarborough, in the 15th Amendment of the Constitution, by its limitation on the power of the states in the exercise of their right to prescribe the qualifications of voters in their own election, and by its limitation on the power of the United States over that subject, clearly shows that the right of suffrage was considered to be of supreme importance to the national government. You couldn't have a national government if the states were allowed to do this. It was not intended to be left within the exclusive control of the states. And here the states are coming up with rules and practices and departures from Article 1, Section 4, the prescribed manner, including court cases, to enforce those rights and those rules. And so what the court said in Ex parte Yarborough is, no, you can't do this. Now then, Article 4, Section 4 of Article 1 of the Constitution, which declares that, quote, it seems simple, doesn't it? The times, manners, places of holding elections for U.S. senators or representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time make or alter such regulation, except as to the place of choosing the senators. And the court says in Yarborough, adopts the state qualification as the federal qualification for the voter. But this right to vote is based upon the Constitution and not upon the state law. And Congress has the constitutional power to pass laws for the free, pure, and safe exercise of this right. That is what the Senate's being asked to do here. Number 11, I've got a footnote, number 11, also Ex parte Yarborough, in which they said, in the case of United States versus Rees, so much relied on by counsel, this court said, in regard to the 15th Amendment, that, quote, it has invested the citizens of the United States with a new constitutional right, which is within the protecting power of Congress. That right is an exemption from discrimination in the exercise of the elective franchise on account of race, color, or previous condition of servitude, including race. This new constitutional right was mainly designed for citizens of African descent. The principle, however, that the protection of the exercise of this right is within the power of Congress is as necessary to the right of other citizens, as Hillary Clinton said yesterday, maybe white communities, to vote, as to the colored citizen. That's the language that the Supreme Court used at that time. And to the right to vote in general, as to the right to be protected against discrimination. Finally, from Ex parte, well, let's see, there might be a little bit more of interest here. The exercise goes on. The exercise of the right in both instances is guaranteed by the Constitution. Should be kept free and pure. Should be kept free and pure by congressional enactments, including the U.S. Senate, whenever that is necessary. And it is necessary to address the abridgment and denial of the right to vote based on race and gender, a clear violation of the U.S. Constitution. And there's a lot more here from the U.S. Supreme Court. What is Chancellor Kent? I believe he was a chancellor in a court of equity in New York State. He's really respected as explaining what the Constitution means on many matters. And he said in the opening words of that part of his commentaries, which treats of the government and constitutional jurisprudence of the United States. This is the beginning of his whole commentaries, which are highly esteemed. Quote, the government of the United States was created by the free voice and joint will of the people of America for their common defense and general welfare. Its powers apply to those great interests which relate to this country in its national capacity and which depend for their protection on the consolidation of the Union. We're talking about if states suspend their democracy, there's a problem of the consolidation of the Union. This is what Kent thought, this is what the U.S. Supreme Court thought. It is clothed with the principal attributes of political sovereignty, and it is justly deemed the guardian of our best rights, as I have said, the source of our highest civil and political duties, as the sure means of national greatness. That's from 1 Kent's Commentaries 201. And the Supreme Court interpreted this, saying, it is essential to the successful working of this government that the great organisms of its executive and legislative branches should be the free choice of the people, as that the original form of it should be so. In absolute governments, where the monarch is the source of all power, it is still held to be important that the exercise of that power shall be free from the influence of extraneous violence and internal corruption. In a republican government like ours, where political power is reposed in representatives of the entire body of the people, chosen at short intervals by popular elections, the temptations to control these elections by violence and by corruption is a constant source of danger, and it is a real danger right here. Now, I just want to pull something out of U.S. versus Classic, which says, such right as is secured by the Constitution to qualified voters to choose members of the House of Representatives and applies to the Senate, is thus to be exercised in conformity with the requirements of state law, subject to the restrictions prescribed by that's Section 2 of Article 1, and the authority conferred on Congress by Section 4, which said that Congress is to regulate this vote. And Congress needs to step in here and stop these voter quotas before they destroy them and destroy the Supreme Court and destroy the United States of America. And so, I'll go on. In Smith versus Allwright then, another case, 1944. This was all white Democratic primaries. Your Democratic Party now is taking away your right. At that time, it took away all the rights of the black voters in Texas, is the state of Texas, to vote in the primary in a federal election. The court dealt with a similar provision to the DNCs in that it excluded voters and members based on their race. In 1932, the Democratic Convention of Texas adopted a resolution that, quote, all white citizens of the state of Texas who are qualified to vote under the Constitution and laws of the state shall be eligible to membership in the Democratic Party, and as such entitled to participate in its deliberations. Like Minnesota, it conditions the participation and voting based on considerations of race. Primaries, it is said, are political party affairs, handled by the party, not governmental officers. No appearance for respondents is made in this court. Arguments presented here by the Attorney General of Texas and the chairman of the state Democratic Executive Committee of Texas. So just like in my case, you had the Attorney General of Minnesota there, Lori Swanson, through Nathan Hartshorn. He has been fighting against democracy ever since I first met him in 2012. And however, those arguments are urged substantially on the same grounds that this is a party affair. The DNC and Minnesota are attempting to do what Texas did, and the Democratic establishment, including judges, are attempting to support them. The legislature of Texas reenacted the article, but gave the state executive committee of a party the power to prescribe the qualifications of its members for voting or other participation, just like 202A.16 of the Minnesota statutes. This article remains on the statutes. The state executive committee of the Democratic Party adopted a resolution that white Democrats and none other might participate in the primaries of that party. Nixon, this is the black voter, was again refused the privilege of voting in a primary. This was rejected for the same reason that the Senate must recognize. We did, however, in United States versus Classic, which I referred to above, we there held that Section 4 of Article 1 of the Constitution authorized Congress to regulate primary as well as general elections, where the primary is by law made an integral part of the election machinery, unquote. There can be no doubt that this applies here. Even the DNC's own rules protect in both primary states and caucus states. So this rule is objectionable whether it's a primary or a caucus state, where Michael Davis tried to uphold it for Minnesota because it's a primary state just like this. But it's the caucuses which kind of pollute those primaries by endorsing somebody, which is very hard to fight. Now, what Bush v. Gore and Carlson versus Franken, two contests, have in common is the role of the courts in involving themselves in elections for the federal government conducted in each of the 50 states. In my contests, the U.S. Senate should respect the constitutional rights. Now, as the court said in Bush, when contending parties invoke the process of the courts, however, it becomes our unsought responsibility to resolve the federal and constitutional issues the judicial system has been forced to confront. Well, the Constitution, the word was never mentioned by the Minnesota Supreme Court. The word was never mentioned by any of the Attorney General's submissions or Al Franken's submissions. Nobody cares about the Constitution, but it says here that they have an unsought responsibility. Well, they certainly didn't seek it in Carlson versus Franken. And in this case, the contending parties did invoke the process of the courts, but as prescribed in advance of the contentions. And what was prescribed in advance was not followed. Creative improvisation by the courts and the DFL officials was acquiescence for Republicans celebrating the demise of the IP, replaced the prescribed will of the legislature. At page 115 of Bush, the court explains this. This inquiry does not imply a disrespect for state courts, but rather a respect for the constitutionally prescribed role of state legislatures, which I've constantly referred to. So this is from Bush v. Gore, to attach definitive weight to the pronouncement of a state court when the very question at issue is whether the court has actually departed from the statutory meaning would be to abdicate our responsibility to enforce the explicit requirements of Article 2. And this, of course, Article 2 deals with the elections of presidents, where Article 1 deals with the elections of Congress. Now, I say to the Senate, your Senate Rule 2 expressly required Dayton to use the language that Franken was selected by the state legislative prescription. But he was not, and all knew this. The legislature afterward repealed this, but only for federal elective offices, while recognizing the importance of a tolling provision left in place to protect the rights of the state assembly, the state legislature. You should return the certificate and make Minnesota follow the law. The U.S. Constitution is what guarantees us a Republican form of government, and you, as the U.S., must also ensure that form of government. And yet, what is being brought to your attention is the loss of the nation's largest then existing political party that falls into the category of independent or third-party voters. This loss is as a result of the two major parties, which, as the debate organizers of Duluth News-Tribune said when asked why Al Franken and Mike McFadden had worked out a completely duopolized debate, excluding the legally qualified party, as well as a legally qualified candidate, which had met the prescribed requirements of the Minnesota state law, which was 5% of the vote. In the first instance, they said the party was excluded just because, apart from Senator Sanders and Senator Angus King, the debate organizers had predetermined that their two parties, Franken's and McFadden's, controlled all or virtually all of the seats in the United States Senate, completely abandoning the law and adopting instead their own standards. It had nothing to do with the rights of the press to edit fora of candidates. This needs to be reviewed as to where it says the IP party was established under the Constitution, whether in fact that has been violated by practices that you have initiated as the Senate or practices you have corrected by law but were not enforced. So it needs to be constitutional, such as HAVA, Help America Voter Act, collecting all these voter email addresses, and equal time requirements. Your job is to enforce this, not only under Section 5, which makes you the judges of elections and returns and qualifications of your membership, but also under your own Senate rules, which were violated. They hold at Senate Rule 2 that the state must select its senator according to its laws. In this case, the governor, a Democrat, Mark Dayton, not only deliberately violated that law of the state, together with Mark Ritchie, DFL former Secretary of State, and participation of that party's Attorney General, Lori Swanson. But they also went ahead and got together Democrats and Republicans and repealed that protection which is required to make Minnesota's contest law constitutional, protecting your jurisdiction, which you must exercise because you have the duty to guarantee, under the guarantee clause, to guarantee a Republican form of government which has been eliminated in Minnesota because the IP party and the independent voters whose preferences lie outside the two major parties has been eliminated. And therefore, the Republican form of government has been eliminated. And I'm asking you to restore this by studying what has happened here on the grounds that this certification was invalid and needs to be recertified and should be recertified by following the state law in place at the time, the 2014 tolling provisions, and under the Senate office contest provisions. I request the Senate to carry out the steps described above and to give me an opportunity to gather and present the evidence of these severe constitutional problems with federal elections in Minnesota, with U.S. Senate elections in Minnesota, and to remedy democracy in America today. I'm Steve Carlson, and I approve this message. This has been submitted to the United States Senate. I hope they will take this duty seriously, because I sure am going to, and I will be campaigning on this, and I will be on a mission for this, to break down the quota system in the United States democracy. We cannot be engineered by race, gender, or other kinds of sexual ideas of any nature.